All right, welcome back to another special broadcast of The Unknown. My name is Michael Volpe. I live in Chicago, Illinois. That's in Cook County, Illinois. And I write at michaelvolpe.substack.com. My broadcast partner, Richard Luthman, he lives somewhere around Fort Myers, Florida. That's in Lee County, named after Robert Edward Lee, the loser of the Civil War. And we are joined by audio. That's not what he looks like at all, I promise you, by Paul Boyne. Paul has, it seems like half his life, he has been under indictment, under arrest by Connecticut for writing mean blog posts. It's a little bit more complex than that. Paul would write things like, this judge is so bad, gave custody to a child molester or an abuser. It would be nice if someone used the Second Amendment. At times, I think in different blog posts, you also released personal identifying information like where these judges lived. The Connecticut judiciary doesn't like you. They, how would I say it? They engaged with Connecticut law enforcement, primarily Connecticut State Police and Virginia authorities, to raid your home, charge you with all sorts of crimes that are very, very dubious. But we want to specifically talk about an aspect of the case that might be blowing up, and I think lawyers call this establishing a foundation. It's directly related to a raid. That's the best I'll describe it. That happened at your Virginia home. I think it was June 30th, 2022. First of all, is that date correct? Is that when the raid occurred?
Yes, 5:15 in the morning, 30th of June. It was a Thursday,
Of two,
2022.
and you still haven't gone to trial. You may go to trial next week, but that gives folks an idea of how long this process is drawn out. So to start the foundation, without any editorializing, just describe what happened that morning
Describe what happened
on
for the
June
raid.
30th, 20 around
Oh,
5:15. Yes.
yeah, 5:15 in the morning. It, there was very heavy pounding on the front door, uh, voices. I jumped out of bed. To, I mean, it was really shocking to get woken up like that. I couldn't understand, couldn't hear. It was muffled voices. People were yelling, bang. The pictures were shaking on the wall. They were banging on the front door so hard. And then I saw the tip of a AR-15 rifle pointed at my head through the window on the side of the door, and I dove back in. Get out of the line of sight. I know the guy had the rifle pointed right at my head because the way the scope light is set up, it was right on my eye. So anyway, Uncle Sam trained me it's not to be a good thing to be in the front of one of those rifles. So I dove back into an adjacent room, and then they started bashing the door down. And they broke the door open, broke the door jamb. And then, I kind of poked my head out of the room and looked down. I was on the second floor, and I'm like, really? You broke the door? And I saw all these little green men with black rifles on the porch, pointing at me. And I'm like, well, okay.
And how
Now,
many people did you see?
oh, there must have been a dozen little green men with rifles. And then later on, there must have been another 20 or 30 cops that came with the big van. There was cars parked all up and down the street. It was quite a fiasco.
Okay. Well, what were they there to do?
Well, they handed me a search warrant, which was blank and said it was sealed and wouldn't tell me anything.
They
They,
handed you a search warrant and if you
yeah, it
read
was,
it, all you saw was blank pieces of
yeah, it
paper.
was just blank, and it was one
So
page. It
they
was a
handed you
search
a
warrant.
blank piece of paper that they
Well,
claimed
they
was
they
a.
handed, I mean, they handed you the form that was a search warrant, but all it said was it was sealed.
Okay.
So whatever that means. And
Right.
I had no idea what they were there for until they introduced me to two Connecticut state troopers. And then I realized what it was.
Okay.
It was
I want to
Connecticut.
make sure you said two Connecticut State
Two.
Trooper.
Now
All
let
right,
me
that'll
let
be
me be.
important, folks, as we go along. Remember, two. Are you sure it's two? Could you be wrong? Did you miscount? It's been a long time since you took math. Are you sure it's two?
Well, I will admit I did not have my glasses on, but I do not suffer from double vision. But the Virginia State Trooper, well, Southern hospitality, he introduced me to two troopers. He even
Okay.
said their names. Well,
Right.
unfortunately, I only ended up talking to McCord, so I don't even remember what the name of the
That,
other one was.
that's Samantha McCord who has a crush on me. She likes to put
Yes,
my name
yes.
into every document she can because she really
Hmm.
likes me. All right. So you started talking to them. It was a search warrant. So did they tell you what they were searching for?
No, but once I realized Connecticut was there, I knew exactly what it was. And I told
Okay.
McCord, I said, this is a repeat of 2017 when the FBI came, but the FBI rang the doorbell.
Hmm.
She
Right.
had no idea what I was talking about. She was clueless.
Okay.
She didn't know the FBI had come in 2017.
And they were coming in relation to a blog that you definitely wrote for called the Family Court Circus.com.
They
Am I
came
correct?
hunting, no, they came hunting free speech. That's
Right.
what they did. End of
Okay,
story.
but I asked not to do the editorializing. It was related to things written on the familycourtcircus.com. Am I right?
Yeah, well, when I got
Okay,
the,
I got it.
I
Oh,
got,
just yes,
I,
I got it.
yes,
That was a
yes,
yes or no. All right.
yes. Okay, go.
Anything else? Did was there any other alleged criminal activity besides the alleged criminal activity that was words in the and photos and maybe video on the family court circus?
No.
So they were criminalizing speech. Am I right?
Yep.
Okay. Did they take anything from your home?
They took all my computers, hard drives, uh, CD disks, thumb drives, couple notebooks, cell phones, um, and then I think they even took like the SD card out of my camera and
Okay.
copied that,
All
but
right.
they left.
Okay. The stuff they took, have you gotten any of those things back?
Nope.
No. All right. Now, about 3.5 years later, things are coming to a head regarding this raid, but I wanted to get the former lawyer who's still very astute with legal stuff to jump in and explain what the problems are here. And as you do that, Paul's attorney, Todd Bussard, wrote a letter, I think earlier this month, or it might have been last month, that I'm going to get up on the screen. And we're going to talk about the letter. But go ahead,
Is that
Rich.
Todd Buster joining us? Did Paul disappear? It looks a lot like Todd. Okay.
Oh,
Anyway,
there you go.
what we have is a situation is this, and everybody who has any familiarity with our system of government understands that in the Bill of Rights, we have something that's called the Fourth Amendment, and that's called the prohibition against unreasonable searches and seizures. And so you
All right,
need to
but
have
let
premises.
me interrupt you. Paul said that a judge did sign a warrant, so it's not unreasonable.
Yeah, and that's fine. And so when we have a search and seizure, that's fine. So let's assume that the search and seizure that happened in Virginia was done by the book. Now, the second issue we have becomes a Fifth Amendment and a 14th Amendment issue that's called due process of law. And
Mhm.
so let's imagine for a moment that the Virginia police executed a warrant signed by a Virginia judge that was all done on the up and up. There were Connecticut law enforcement present, notably, admittedly by Jack Doyle, the state prosecutor. And so we have a situation that's called dual sovereigns. We have two sovereigns that are involved at this point. And so under due process, there has to be what's called a chain of custody of the evidence going from one sovereign, the collecting sovereign, which is the Virginia State Police, to this next sovereign, the Connecticut courts or the Connecticut executive branch here, the Connecticut State Prosecutor, that's prosecuting Boyne in Connecticut. And the situation that we have, the constitutional issue here is something that's called the Silver Platter Doctrine. And that doctrine says that you cannot take evidence that has been either illegally obtained or illegally custodied and cataloged and not transferred correctly and handed on a silver platter from one sovereign to the next. You cannot violate the law in order to get a conviction in any way, shape, or form. And what we have here is a question that's being asked. It was first asked back in 2023 by Paul's previous lawyers at the Kirschbaum firm, Jen and Alice, who asked, okay, where's all the stuff from this raid? In 2023, they asked, get us all this information about this Virginia raid so that we can see that everything under Virginia is done correctly.
Hold on. Let me interrupt you. We have a warrant. I think you guys aren't arguing that a judge didn't. What else would we need? They have a warrant. What else could they possibly need to give them?
Gain of custody. So the warrant says something very specific, Michael. It commands the officers to do something very specific in Virginia. That's what a warrant does. The particularity requirements of warrant, the warrant tells about the places to be searched, the things to be searched. There's a particularity requirement. So first, if the warrant's a valid warrant, we have to see that the Virginia State Police executed it correctly. They didn't go outside the bounds of the authority granted by the Virginia judge. Number two, what did they take? What did they take from the residents? Did that comply? Number three, did they catalog it correctly? Number four, did they bring it back in accordance with Virginia law and custody it with the Virginia police? Number five, under Virginia law, that custodied evidence has to be further released by the order of a judge in Virginia. That's the order made? Number six, after that Virginia order was made, was it transferred directly to whom? To Connecticut authorities? How was it transferred? How do we know that the seal on the evidence that says this is all authenticated evidence is correct? You have to go through every one of those steps. And when you go through those steps in the chain of custody, you see that this looks like it fails. We don't have all the evidence yet. We don't know, but it appears as if there's a blatant failure in the chain of custody.
Hold on. You just provided, I think, 5 or 6 steps that need to be taken in order to properly give this evidence from Virginia to Connecticut. How many of these steps has Connecticut shown beyond any doubt they were taken so far?
Let's cut to the fat. Paul, you can join in here. To your knowledge, Paul, after a warrant is issued in Virginia, is there a rule that the evidence has to be held by the Virginia authorities until further order of the Virginia judge?
Well, the Virginians, knowing that the Constitution exists, installed in their statutes protections, Fourth Amendment protections. And there's 2 statutes. One that says the court issues a search warrant and they seize stuff, and that stuff has to be held securely until further order of the court. Meaning that
Paul, let me just interrupt you. I've got the statute up, but go ahead.
Oh, yeah. What are we at? 19.2? No,
go back up. It's the section up there, Mike. C6?
It should be it should be 19.2-58 and 57.
Right there, 8-8. Yeah.
No, you're in the wrong place. 19.2.
Yeah, this is the second part.
Paul, keep explaining. It's all right. Keep explaining.
Right. Okay, so here's the deal. The court issues a search warrant. The court issues orders on how it's to be executed. All right. Search warrants are supposed to be executed peacefully, not banging on the door early in the morning. The only reason we use SWAT raids in Virginia is usually for like armed drug dealers, but then there's Paul Boyne, and he's a big threat to nobody. So Sponheimer brings in the SWAT team.
Wait, Paul, Sponheimer is whose?
Oh, Sponheimer is a bald-headed little shit, 26. At the time, he had 26 years on the force as special agent, Virginia State Police.
All right, he's a Virginia State Police trooper. All right, hold on, Paul, settle down. All right, I just wanted to add one other thing. Your attorney, Todd Bussard, mentioned an article that we're going to talk about later, but I want to draw the audience attention to it. It's called, is it up here? Right here. I'm sorry. State police serve search warrant in Virginia, part of an investigation of alleged internet threats against judges. That will be important. It was written by Ed Mahoney of the Hartford Courant. But go ahead. Keep talking about the other things that must be done to make a search warrant legal.
Okay, so you get a search warrant issued by a judge after she finds probable cause of a crime, implying that the judge actually read the application, which in this case, Judge Saylor didn't. Judge Saylor did not read it. She just glossed over it, signed it, handed it back to Sponheimer. Anyway, so you seize whatever is to be seized, and then basically it gets logged in and it goes to the evidence locker. And then if you want to search a computer that you seized under that warrant, you have to go back to the court and say, I want to search this computer, and this is why, and get a search warrant to invade the computer. Well, all Sponheimer did was the raid was over like at 7:15 in the morning, and they were all gone. And at 7:39, he signed over everything to McCord, and McCord put it in the trunk of her car or whatever and headed off to Connecticut, violating Virginia law.
Okay. Now, Paul, before you go, I want to go back and I want to drill down on this, and then we're going to get to the meat of this issue. Were you ever shown any Connecticut or Virginia order authorizing Connecticut officers to participate in the search inside Virginia? Did any judge, Connecticut or Virginia, ever sign off on them?
No, there's nothing. The courts, I don't even think Judge Saylor or wait a minute. I don't think Judge Saylor or Judge Smith had no idea that the Connecticut troopers were there.
I'm going to give you a couple of rapid fire questions here, Paul. Just pretty much yes or no with maybe a
all right, go.
Okay. Next one. Okay. Did the officers explain, Virginia or Connecticut, at the scene, where the seized property would be transported and who would maintain custody? Did they tell you that at the scene?
No.
Okay. Did any point during the search?
Oh, wait a minute. Let me back up on that. There was a guy from the Richmond Computer Crimes Lab. He had gotten up early that morning and driven all the way north to be there for the raid. I had a long discussion with him in the kitchen, and he was going to take that stuff back down to Richmond. And we actually discussed the computers. And I told him, which computer, I think one had the vault on it and one wasn't. And he said, no problem, we can get into the vault. And so it was very clear to me talking with that guy that he was going to take all that stuff back down to Richmond. Okay. End of story.
Next question. At any point during the search, did you hear discussions suggesting any uncertainty about legal authority? Meaning, did the officers call the prosecutors? Did they call attorneys? Did they call anybody for guidance mid-search about these issues?
No.
Was Jack Doyle on the phone with anybody?
Nope.
Okay. Now, your understanding as a layperson, okay, can a Connecticut officer operate in Virginia without the direction and control of the Virginia authorities or an order of the Virginia courts?
No, and it was very clear because when McCord and I were chatting, she made it clear that she wasn't acting as a law enforcement officer. And I'm like, no kidding. You're from Connecticut and you're standing in Virginia. You're a nobody. You're a tourist.
Okay. Now, Mike, can you get up the order to show cause that was just signed by Judge Brown?
All right. So all of this came to a head, if you will, because Connecticut prosecutors have not been able to provide the documents. And what we looked at before was not even a discovery request, but Todd Busser going through how many discovery requests have been ignored or not properly done. So basically, Connecticut has not given you any of the documents that you've asked for, maybe not any, but most of the documents you've asked for related to this search. And as a result, they have blown through deadlines on discovery requests. And a judge that you don't like has issued, I guess you'd call it a favorable order. And let's read it because it's only 2 pages. On December 11, 2025, the court ordered the state to produce all outstanding discovery by January 5, 2026. The court held a hearing on January 14, 2026, to discuss the status of the state's compliance with the court's order. Based upon that hearing, the court has determined that the state has not fully complied with this court's order. Accordingly, the court issues the following order to show cause. The state is ordered to show cause as to why the charges in this matter should not be dismissed, or in the alternative, why the state should not be precluded from introducing evidence related to or derived from the June 20th, 2022 search, we call a raid, of the defendant's Virginia residence. The following documents are ordered to be produced along with the custodian of records. Emails between Connecticut State Police Detective Samantha McCord and the Virginia State Police between January 2021 and September 2025. Any attachment to the Virginia State Police activity report, whatever the file number is, filed July 8, 2022. The entire file from the Virginia State Police internal affairs investigation concerning and or related to the defendant purportedly opened by the Virginia State Police in July 2022. Any documents from the Connecticut State Police regarding the identity of all Connecticut law enforcement personnel who were physically present and or participated in the search and or seizure of items from defendant's Virginia residence on June 30th. The hearing on this court's order to show cause will be held on Thursday, January 22nd, 2026 at 10 a.m. All subpoenaed document and custodial records be present. Now, I wanted to
read the next week. Read that most important thing there. You missed the most important thing right there for a matter of a trial advocacy perspective. Put that back up. The last 2 sentences, they hide them in the end. You think you've read the most of it. What does it say right there at the end? It says,
all right, hold on, we got it wrong. Here we go. All right, the last 2 sentences. The hearing on this court's order to show cause will be held on Thursday, January 22nd, 2026 at 10 a.m. All subpoenaed documents and custodians of record are ordered to be present. The court, at the conclusion of the hearing, will entertain any further argument regarding dismissal or preclusion. Jury selection will start the following day, Friday, January 23rd, 2026.
That again, Michael. Jury selection will start the following day, right? How can you have jury selection if they admit that Paul has not had the evidence given to his attorneys and they've not had an ability to use it? Look at all this stuff. It's a mountain.
Right. So he's already decided that the trial is going to move forward no matter what they bring in. But I agree with that. And Paul, when were you first arrested in Virginia? As close to the exact date as possible.
Like the 21st of July, 23.
All right. So if this trial goes on as scheduled, we are looking at 2.5 years from the arrest to the trial, even though it is enshrined in the Constitution that you have a right to a speedy trial. I don't think any one of us agree that it's speedy. Now, I wanted to get up an article by Ed Mahoney, and I want to show a couple of things from the article, and then we're going to talk about the controversy. So here's the article. I'm going to read the first paragraph, and then we're going to get to the important part. In a case with free speech implications, authorities have seized computers and other material from the home of Virginia man suspected by multiple law enforcement agencies of being associated with years of alleged hateful internet messaging targeting Connecticut judges. Folks, even if you really were part of a group that had hateful internet messaging against Connecticut judges, that's not illegal. But the important part, I believe, is right here. The latest search warrant was signed by a Virginia judge and served by the Virginia State Police because Connecticut law enforcement lacked the authority to do so in other states. 2 Connecticut detectives were present, and the seized electronic equipment has been transported into Connecticut where it will be examined. So, Ed Mahoney, who wrote this article for the Hartford Courant, agrees with you that there were two Connecticut law enforcement agents at this raid. Why is that important? Why does that matter that there were 2 there, Paul?
Well, there was never any debate that there was 2 there.
Mm-hmm.
I mean,
but why is that suddenly? Paul, you're getting away. Why is that suddenly a controversy?
Because in the hearing before Brown the other day, Jack Doyle, the $215,000 a year excuse of a paycheck sponge, told Judge Brown, I confirmed with the Connecticut State Police that there was only 1 trooper there. And at which point I called bullshit. And so,
okay.
I mean,
all right.
I told Brown there was 2 of them, McCord and her little sister, and they were in matching Connecticut police fleeces embroidered with Connecticut State Police under the left shoulder. I mean,
right.
Doyle is just being an idiot, okay?
Okay, all right. So he's created another problem for himself. And frankly, I think the article confirms most of what you said. And it was written shortly after the raid. So all of these things that needed to be done before the evidence could move from Virginia to Connecticut, it sounds like there wasn't even enough time to do that. So the article basically confirms what we've been saying.
Look,
this was done illegally.
Forget Ed Mahoney being a confirmation source. Okay. That article came out like 4th or 5th of July.
Mm-hmm.
All right. And the warrant was still sealed.
Mm-hmm.
But they'd already given the warrant to Ed Mahoney up in Connecticut.
Mm-hmm.
So when I went before Judge Smith on the 8th of July, I said, well, you got to unseal it because they already gave it to the Hartford Courant.
Right.
So,
hey,
I mean,
Rich, is it legal for law enforcement to leak a sealed warrant to media?
Not legal to leak, but that's the issue. The issue, you have press protections that the press wouldn't, in Connecticut especially, the shield law says they don't have to give up their source. So everybody kind of knows what happened. It's like tell the Godfather what everybody else needs to know type thing. It's one of those. It's one of those things. But I want to go back real quickly. I want to be technical here for everybody that's watching. The link that I gave you to the statute. Click that again, and I want to just show everybody what we're dealing with here to show that if we're going to take Ed Mahoney and the Hartford Courant as true, and they said in that second sentence of that paragraph that they handed all the stuff over to the Connecticut police. So see this where it says here. You're gonna go down a little bit more. I think it's part 7. It's the compelling. Here we go. Stop right there. Go back. You didn't put past it too far. Go back up. Uniform interstate. Go back up right there. Uniform Interstate Deposition Discovery Act. That's a uniform law that is in every state of the union, and it's been enacted everywhere, including in Connecticut and in Virginia. And in Virginia, it talks about how you could properly take the statement from the judge ordering a search and ordering evidence and domesticate it in Virginia and then turn over the evidence to Connecticut. And so what Mahoney said is that they searched in Virginia and then they handed it over to McCord. Well, that would be illegal under Virginia law. You need to go under the Uniform Interstate Deposition Discovery Act. You have to issue the subpoena under Virginia law. So the Connecticut judge, Brown in this case, only issued this subpoena the other day. Now what they have to do in Connecticut is take this and bring it down to Virginia to domesticate it, right? And then they would have to serve it on the Virginia State Police, who would have an ability to object based on privilege, ability based on redaction, based on scope, all different reasons. And then the court would order it turned over in Virginia to the Connecticut authorities. None of that happened here, and it was already handed over to the Connecticut police. So this is an issue of chain of custody that we spoke about before. Okay, so Paul, I want to go back to the line of questioning that I was giving before in order to talk to you about this, to make it very clear on this record what happened. Okay, so the evidence moving from Virginia to Connecticut, okay, prior to this order to show cause by Judge Brown, have you ever been shown proof that subpoenas or orders were properly domesticated in Virginia from Connecticut before the evidence was transferred to Trooper McCord?
No.
Paul?
I mean, the
Have you
evidence
ever-
was
Yeah.
the evidence
No,
was
I think
transferred
yes
at
or no.
7:39 in the morning. The
Okay, so
courts
there
were
was
not
no.
open. The
Okay,
courts
so
were
wait a
not
minute.
open.
So that's true. As of today, has the state of Connecticut produced a Virginia-issued subpoena, court order, or domestication filing covering the emails between the Virginia and the Connecticut police, the Virginia State Police activity reports, the internal affairs materials, or anything else that's covered under the search? Has there been any issued subpoena, court record, or domestication filing filed in Virginia?
Okay. First off, Jack Doyle. Wait a minute. You're asking if there's any subpoenas from Connecticut
That were filed. A simple question: were they filed?
No,
Because
No, that's
no,
it.
because
That's it. Go on to the next
here's
question.
the
Rich, go
issue.
on to the next question.
No, you're missing the point. The prosecutors in Connecticut do not have authority to issue subpoenas. So Jack has to go to the court and get Judge Brown.
He just did, Paul. He just did. He got that order to show cause. That will serve as something that can be domesticated. But there was nothing prior to this. Is that correct?
No.
Okay.
The
All right,
order
Paul,
to show
Paul,
cause
stop
is
talking,
not the
Paul.
subpoena.
Stop talking, Paul.
Oh,
Go
you
ahead,
guys
Rich.
are off the deep end.
I know that, but I'm asking you that this is the only piece of paper legally that the court has issued at all. That's all I'm trying to get to.
It's not issued to Virginia.
Okay, well, here's the point. If evidence obtained in Virginia was done so without proper domestication under Virginia law and under Connecticut law, can it be legally brought into your criminal case? Yes or no?
We've known that since day one.
Now, here's the important point. From your review of the filings, from our review of the filings, 2022 search, 2023 request, the problem here is a delay and a failure to follow the required interstate procedures altogether by Jack Doyle in the state attorney's office. Is that correct?
Correct. They broke Virginia law.
I have another question.
Doyle,
I have another question. If we're seeing all of these legal problems with the way the key piece of evidence was collected, why is the judge in this case still moving forward with starting the trial the day after they hold a hearing to basically to conclude whether or not any of this evidence will be in play? Why would the judge continue with this trial the day after this hearing if there are this many problems with the way this evidence was collected?
Who do you think the judge is working for?
Not for justice. Who is he working for?
He's going to be beaten silly by Joette Katz and the ADL people that are behind this.
All right. Okay.
End of story.
This is a rigged case. Rich, go ahead.
Okay, I'm gonna ask very specific questions. I have 3 or 4 different silos I want to go through to make it very clear that this evidence is no good. First part, okay? The court has ordered production, and you've always wanted production of emails between Sammy McCord and Virginia State Police, Spottenheimer and others, okay? 2 questions for you, okay? Why are these emails so important, and what does it tell you that years later, these communications still haven't been fully produced? What's in them, and how harmful is it to the state's case?
It's a death knell to the state's case because we have obtained some emails from Virginia State Police, some email threads, partial email threads that include emails back and forth with McCord. And basically what that shows is that Jack and McCord gave Spottenheimer all their viewpoint discrimination, saying, we're investigating this guy. We don't like what he says. We want you to go raid his house. Spottenheimer took all that, pasted it into a Virginia format for a search warrant, sent it back to McCord and said, "Is this what you want?" So McCord and Doyle approved it, sent it back to Sponheimer, who took it to the judge and got a Virginia warrant. There was also
Rich,
a
what's wrong with that?
discussion
Hold on. What's wrong with that? It's not his
because there was
investigation.
no
Paul,
crime.
please stop talking. It's not
It's-
his investigation. What's wrong with that?
No, I'm in Virginia. I'm in Virginia, Mike.
Paul,
Yeah,
stop
stop for a second.
talking.
There,
Rich.
there could be an issue here, and what the issue Paul's getting at is this: Connecticut cannot delegate, and Virginia cannot receive delegation of its sovereign powers from another sovereign. So the Spottenheimer had an obligation as a law enforcement officer to independently use his brain and see if this was an actual something that was against the public policy of Virginia. But also the judge that signed the warrant had an obligation to do so too. So we don't want to confuse judicial immunity and police immunity for signing a validly signed warrant, or one that was actually titularly signed, with the validity of the warrant itself. The warrant appears that there's an argument that it was issued and it's defunct as a matter of law, because the search that was requested by the Virginia trooper from the Connecticut people violates Virginia law. So that's one legal argument that Paul is talking about. But I want to talk about the second part that's a very important part, about chain of custody. And I'm going to ask you another two-part question here. Okay, has the Virginia State Police or the state of Connecticut ever produced a complete chain of custody showing how the items from the 2020 search moved A, from your Virginia home, B, to the Virginia State Police, C, to the Connecticut State Police, and D, to the Connecticut State Labs? That's number one. And number two, if this chain of custody is broken or undocumented, what does that do to the prosecution's case?
Answer to number one is no. There is no chain of custody. Answer number two is all the evidence goes out. And since the arrest warrant was based on a search of the computers, I guess that throws the arrest warrant out, and out goes the case.
Okay, great. So next part. Judge Brown issued an order to show cause based on the fact that on January 5th, 2026, all of the discovery was due to your defense counsel. And January 5th came and went, and they failed to produce the documents. So tell me a couple of things. Okay, the judge issued the order to show cause. Okay, what did Jack Doyle fail to do? Number one. And then when the court asks for the custodians of records to appear in person, A, who is he asking for? And B, can the court even order those people?
Yeah. All right. Well, the last question. So you're saying Brown ordered the appearance of the custodian, and Brown really got jacked up because we had been asking for McCord's emails for most of the year. And Jack has a funny way of talking to the judge. He keeps telling the judge, "I've requested that, and I've turned over everything I received." And of course, we didn't receive any. And then the judge asked some hard questions to Jack, saying, why haven't you received them? And then Jack finally said, "Well, I keep asking the Virginia State Police, and they don't provide it." Okay, whatever that means.
That goes back to the first question. What specifically did the court find or ask that the state failed or may have failed to do? The big thing is that on January 5th, you didn't receive the discovery. But you're saying that Jack is saying, well, it's not my fault, it's other people's fault. But from what you've seen so far, do you believe that Jack Doyle in the state attorney's office has done what they needed to do to properly obtain the evidence from the state of Virginia?
From the state of Virginia? They haven't even done it to obtain it from the state of Connecticut. McCord's emails are on a server in ct.gov, and all they have to do is go to the IT department and say, boom, I want her emails, and No, Jack's not doing that. Jack requests it from Virginia State Police, who doesn't respond.
Okay.
So you know what Virginia State Police is trying to hide. I'm sorry, Connecticut State Police is trying to hide.
All
They
right.
won't even cooperate with their own
Hang on.
prosecutor.
Let me
So
ask
here-
you a question. Hold on. Let me ask a question. Your previous lawyers first asked for all of this information in late 2023, I believe. So we're
Correct.
looking at a little bit more than 2 years. Why has this not been resolved in 2 years? Why has this dragged on for as long as it has?
Because the game was, from the start, you were not going to convict somebody in Virginia on a Connecticut stalking law for free speech. Was never going to happen.
Mm-hmm.
Illinois struck down the same law in 2017.
Mm-hmm.
District of Columbia struck it down in 2023.
Mm-hmm.
The law that Connecticut is using has never been upheld. There was a discussion before Brown. We're in uncharted territory. This law has never been tested.
Mm-hmm.
Is it
Okay.
constitutionally sound? Nobody
Well,
knows.
why
But we're
does
going to go
that
to
mean?
jury.
What
Now-
does that have to
Wait
do
a
with?
minute. I got to finish the rest of it. So the game was, we arrest them, we drag them to Connecticut, and we hold them in jail with a high bond, and then we dangle a plea deal in front of them. And then I would have pled out, and that would have been the end of it. And guess what? I didn't take the plea deal.
But if your previous lawyers asked for this in 2023, why is it still an issue in 2026?
Because they were not pursuing it, and neither was Jack. And the
Okay.
whole game
Ah.
was get them
So
to plead out.
everyone went through the motions. Bussard finally pressed the issue, and it forced people's hands. And suddenly we've got an order that looks like it's pretty tough. But we'll see how it plays
No,
out.
I don't think you've got an order. I think you've got a jury selection next Friday.
Mhm.
What
Okay,
good is
now-
the order?
Well, here's my question now. The motion on the table is for dismissal or preclusion because of the evidence. And so I'm going to ask a couple of questions about that. First, well, you know what dismissal is, right? That's one consequence. The other consequence is preclusion. So practically speaking, Paul, if the evidence from the Virginia search, as well as the Connecticut-based evidence about the Virginia search, is precluded, right? How much of the state's case remains? What other evidence do they have in your opinion?
What other evidence do they have?
Yeah, is everything that comes out of that after the fruit of the poisonous tree? Is there anything
Well,
else left in the case?
no. I mean, if that evidence from the search goes out, the case is gone.
So your belief is that everything is fruit of the poisonous tree. If the Virginia search and the Connecticut evidence on the search, if that's precluded, everything should be precluded.
Yeah.
Okay, next part. We talked about this, me and you. From a constitutional standpoint, let's talk about the due process concerns. Do the missing communications and reports that we're talking about, both Virginia and Connecticut, the ones in Connecticut custody as well, emails and everything else, potentially qualify as Brady material, meaning that the evidence may be exculpatory or tending to prove your innocence? Do you believe that?
Oh, yeah, no. Brady was discussed in great length during the hour-and-a-half hearing this week. And Jack kept telling the court, oh, we're well aware of our responsibilities under Brady, and we're going to get this and review it for any Brady material, and Brady this and Brady that. And Todd was saying, hey, the prosecution's got a Brady responsibility to disclose these things, and here we are, and he even said, basically 2.5 years after arrest, and the prosecution hasn't disclosed what's required under Brady.
Right. All right.
So,
And
I mean, you
for
just say
those-
Brady and this
I got
case
it.
is over.
Paul, I got it. For those who don't know, Brady refers to Brady versus Maryland, a landmark U.S. Supreme Court case, which, as Rich described, says there is no option that prosecutors shall turn over any material that is exculpatory or will help the defense. And if you withhold it, that is enough to dismiss the case. So that is what you guys were all referring to.
And I want to make a very important point about Brady for our audience, and Brady and its progeny, the cases that came after Brady from the Supreme Court, also the Supreme Court of Connecticut, the Second Circuit, many of the circuit courts. Brady means that not only does the government have to disclose exculpatory material, but they have to disclose exculpatory material in a manner in which and in a time in which the defense counsel can make good use of it. So I'm asking you, Paul, about prejudice. And the search occurred in 2022. And as Mike just said, we're now in 2026. How does this delay factor into your ability to do several things and your attorney to do several things, like A, challenge the search, B, examine or subpoena the witnesses to the search, both in Connecticut and in Virginia, and C, test the integrity of the purported evidence that the state would wish to offer? How does that prejudice you?
There's no time to do it, and there's no resources. Todd can't handle it. He doesn't have any staff, and this is just and Brown knows it. He's just railroading it right to a jury. I mean, all that stuff is just going to be left by the wayside. I mean, prejudice, prepare for trial. I mean, in the practice book, they have this thing that says it's supposed to be 45 days between end of discovery and trial.
Right.
Okay, we're not done with end of discovery, people.
Right.
So, Paul, your belief then, your statement here today, your opinion here today is that if this case goes to jury selection as scheduled, even if somehow miraculously and magically Todd were to receive all the requested materials at the next court date, you would still be prejudiced in the selection of a jury and going to trial because your attorney didn't have a chance to review those documents and didn't have a chance to investigate and make use of those materials. Is that what you're trying to say?
How are you going to come up with voir dire questions for the jurors if you don't know the discovery?
Right.
You can't. You can't do it.
Here is a court process that has delayed this trial many, many times, but is now insisting on moving forward with the trial a day after they hold a hearing on missing evidence. That's all you need to know. I'm done, Rich. Do you have any other questions, or should we wrap this up?
Yeah. There's one point, and I mentioned this to Rich, which you go back to Samantha's reaching out to Virginia saying, we want to investigate this guy. Okay. When she did that, no judicial authority in Connecticut had established probable cause. Okay. So she does not have the authority to reach across state lines and act on the behalf of Connecticut saying, I want you to investigate this guy living in Virginia. So right there, that kills the case. Fourth Amendment violation out of the gate.
Okay. Rich, you got anything?
So you're going up to Connecticut next week, Paul?
If Todd doesn't withdraw, and I don't know. I mean,
so
supposedly
you're scheduled to appear in the Connecticut courts next week and then collect the jury next Friday, correct?
Yep.
Okay.
Another train ride.
And just a final point, have you spoken to Ed Mahoney or the Courant, and are they going to be covering this?
Yeah, I've been keeping Ed up to speed. I call him every now and again. He's really not interested. He's always too busy with doing something else.
He refuses to cover a part of the case that cites his own article. That's all you need to know about Ed Mahoney at the Hartford Courant. Paul, thank you for being here.
Yep.